After studying this module, we shall be able to know the meaning and nature of share, understand kinds of shares, learn the meaning of allotment of shares, identify the general principles and statutory provisions of allotment of shares.
The Companies Act defines a share as a share in the share capital of a company and includes stock. This is covered under Section 2, subsection 84 of the Companies Act 1956. A share is the interest of a shareholder in the company measured by a sum of money for the purpose of liability and interest thereto, and also consists of a series of mutual covenants entered into by all the shareholders inter se in accordance with the provisions of the Companies Act and Articles of Association. A person holding a share is entitled to enjoy not only the contractual rights but also those rights which have been given to him by the Companies Act. It secures to its owners the right to receive a proportionate part of the profits, if any, and the proportionate part of the assets of the company upon liquidation. On the other hand, the shareholder may also be required to pay full value, that is, amount unpaid on a share held by him at the time of winding up. Shares or other interest of any member in a company is a movable property transferable in the manner provided by the articles of the company. Each share in a company having a share capital is distinguished by its appropriate number called distinctive number unless the shares held are a depository in a demat form as provided under section 45 of the Act. A share cannot be further subdivided. Directors have the power to issue shares on behalf of a company subject to the provisions of Articles of Association. They must, however, use this power bona fide for the benefit of the company.
Share capital of a company is divided into units. Each unit is called share. That means share is a fractional part of the capital of the company. There are different kinds of shares. The board of directors of a company has the power to issue shares. As per the Companies Act, a share is a share in the share capital of a company and includes stock. A share is the interest of a shareholder in the company measured by a sum of money for the purpose of liability and interest thereto, and also consists of a series of mutual covenants entered into by all the shareholders inter se in accordance with the provisions of the Companies Act and the Articles of Association. A person holding a share is entitled to enjoy not only the contractual rights but also those rights which have been given to him by the Companies Act. It secures to its owner the right to receive a proportionate part of the profits, if any, and proportionate part of the assets of the company upon liquidation. On the other hand, the shareholder may also be required to pay the full value on winding up. Shares or other interest of Any member in a company is movable property, transferable in the manner provided by the articles of the company. As per Section 45 of the Companies Act, each share in a company having a share capital is distinguished by its appropriate number called distinctive number unless the shares held are with a depository in a demat form. A share cannot be further subdivided. Directors have the power to issue shares on the behalf of the company subject to the provisions of the Articles of Association. They must, however, use this power bona fide for the benefit of the company.
Before moving further, it is very important for us to understand the difference between share and stock. Stock is the aggregate consolidated holding of the share capital of a person in the company. It can be divided and transferred in any fractions and subdivisions without regard to the original face value of the shares. Fully paid up share capital may, if the articles so permit, be converted into stock by passing an ordinary resolution in the general meeting of the company. Conversion of shares into stock does not alter the relationship between the holder and the company. The holder still remains a member. The holders of stock shall accordingly to the amount of stock held by them have the same rights, privileges and advantages as regards dividends, voting at meetings of the company and other matters as if they held the shares from which the stock arose, but no such privilege or advantage except participation in dividends and profits of the company and in the assets of the company at the time of winding up shall be conferred by an amount of stock which, if existing in shares, would not have conferred the privilege or advantage. Stock may be reconverted into shares again by an ordinary resolution. Conversion of shares into stock or vice versa is not prevalent in India. A share may not be fully paid up, but a stock is always fully paid up. A share has a nominal value, whereas a stock cannot have a nominal value. A share cannot be transferred in small fractions, while a stock can be transferred in any fractions. All shares bear distinctive numbers except when held in demat form, while stocks disclose the consolidated value of the share capital. Fractions of the stock do not bear any number. All shares are of equal denomination. Stock may be of unequal amounts. Unlike shares, stock cannot be directly issued in the first instance. Only fully paid up shares can be converted into stock.
As per Section 43 of the Companies Act 2013, a company limited by shares may issue following kinds of shares: preference shares, equity shares, equity shares with differential rights, sweat equity shares, preference shares. Preference shares with reference to any company limited by shares are those which carry the following preferential rights over other classes of shares. A. A preferential right in respect of a fixed dividend. It may consist of a fixed amount or a fixed rate. B. A preferential right as to a repayment of capital in the case of winding up of the company in priority to other classes of shares. Preference shares are of different types. Cumulative preference shares. A cumulative preference share has a right to claim the fixed dividend of the current year out of the future profits. The dividend in these shares accumulates unless paid. The accumulated arrears of dividend is to be paid before anything is paid out of the profits to the holders of any other class of shares. If a company is unable to earn sufficient profits in any year to pay dividend on preference shares, the deficiency is made good out of the profits of the subsequent years. Preference shares are always cumulative unless otherwise expressly stated in the Articles of Association. Non-cumulative preference shares. Dividend on non-cumulative preference shares can be paid only out of the profits of that very year and is not allowed to accumulate to be paid out of the profits of the future years. The right to claim dividend will lapse if there are no profits in a particular year. Participating preference shares. Besides a fixed rate of dividend, the holders of these shares are also entitled to participate with the equity shareholders in the surplus profit which remain after paying dividend to equity shareholders up to a certain limit. They may also be entitled to get a share in the surplus assets of the company on its winding up, unless expressly provided in the articles. Preference shares shall be presumed to be non-participating. Non-participating preference shares. The holders of these shares are entitled only to a fixed rate of dividend and do not share in the surplus profits. The whole of the surplus profit will thus go to the equity shareholders. Convertible preference shares. The holders of the shares have a right to get converted their preference shares into equity shares within a certain period. Non-convertible preference shares. These preference shares do not carry the right of conversion into equity shares. Redeemable preference shares. Shares which can be redeemed after a fixed period or after giving a certain notice at any time at the will of the company out of the profits of the company or the sale proceeds of the new shares are called redeemable shares. Irredeemable preference shares. They are of the nature of a permanent and perpetual liability which cannot be redeemed during the lifetime of the company. The Companies Act does not permit a company to issue any preference shares which are irredeemable or are redeemable after 20 years from the date of the issue. Equity shares. Equity shares with reference to any company limited by shares are those which are not preference shares. They do not carry any preferential rights. For the purposes of dividend and repayment of capital, they rank after the preference shares. They have the right to participate in the decision making of the company. They are entitled to voting rights. They receive dividend out of profits as declared in the annual general meeting only after preference shares have been paid their fixed dividend. Equity shares with differential rights. As per the company's issue of share capital with differential voting rights rules 2001, a company limited by shares may issue shares with differential rights as to dividend, voting, or otherwise subject to the following rules. The Articles of Association of the company authorize the issue of these shares. A company is allowed to issue equity shares with differential rights only to the extent of 25% of the total issued share capital. Approval of the shareholders is obtained by passing of ordinary resolution at the general meeting. A listed public company is required to pass the resolution through postal ballot. The company has distributable profits in terms of Section 205 of the Companies Act for the 3 financial years preceding the year in which it was decided to issue such shares. The company has not defaulted in filling annual accounts and annual returns for the 3 financial years preceding in the year in which it was decided to issue such shares, and the company did not fail to repay its deposits or interest thereon on the due date or redeem its debentures on the due date or pay dividend. The company has not been convicted of an offense under the SEBI Act, Securities Contracts Regulation Act, or the FEMA Act. The company has not defaulted in meeting investors' grievances. A person holding any equity share with differential voting rights shall be entitled to bonus shares, right shares of the same class. A register of members with all relevant particulars of the shares so issued and the shareholders should be maintained.
Sweat equity shares mean equity shares issued by a company to its employees or directors at a discount to the market price or for consideration other than cash for providing know-how or making available rights in the nature of intellectual property rights or value additions by whatever name called. According to section 54 of the Companies Act, a company may issue sweat equity shares of a class of shares already issued if given conditions are fulfilled. A. The issue is authorized by a special resolution passed by the company. B. The resolution specifies the number of shares, the current market price, consideration if any, and the class or classes of directors or employees to whom such equity shares are to be issued. C. 1 year should have elapsed at the date of such issue since the date on which the company had commenced business, and D. Where the equity shares of the company are listed on a recognized stock exchange, the sweat equity shares could be issued in accordance with the regulations made by SEBI, and if they are not so listed, the sweat equity shares are issued in accordance with such rules as may be prescribed. 2. The rights, limitations, restrictions and provisions applicable to equity shares shall be applicable to the sweat equity shares issued under the section, and the holders of such shares shall rank pari passu with other equity shares.
Our next topic of discussion is allotment of shares. Prospectus issued by a company is an invitation to the public to make offer, that is, to apply for the company's share. Application for share is the offer from the application to purchase shares. An application for shares does not give rise to a binding contractual obligation between the company and the applicant, because it is offer in response to invitation to the public by the company to subscribe for securities. Allotment of share is acceptance by the company of the offer. The communication of acceptance of this offer by an allotment order or notice gives rise to a valid contract between both the parties, the company and the shareholder. Allotment means the appropriation out of the previously unappropriated share capital of the company. Allotment is the acceptance by the company of the offer to take up shares. Allotment of shares is usually done by a resolution of the board of directors. General principles of allotment of shares. Allotment of shares is a contract between the company and the person to whom the shares are allotted, that is, allottee. The allotment to be valid must comply with the following general principle regarding allotment. Allotment should be made by proper authority. The duty of allotting shares is of the board of directors of the company. The board should pass a resolution of allotment at its meeting. It should be made within reasonable time. Allotment must be made within a reasonable period of time. Otherwise, the offerer may refuse to take the shares. What is reasonable time is a question of fact in each case. It must be communicated. There can be no binding contract unless acceptance to the offer is properly communicated to the applicant. Posting of a properly addressed letter of allotment will be taken as a valid communication even if it is delayed or lost in the course of transit. It should be absolute and unconditional. Allotment must be absolute, unconditional, and must confirm to the terms and conditions of the application. Otherwise, the applicant will not be bound to the allotment. Let us now discuss the statutory provisions on allotment of shares. Company law does not impose any restrictions upon a private company to allot its shares, but a public company offering shares or debentures to the public for subscription cannot proceed to make a valid allotment unless it complies with the requirement of section 39 to 40 of the Companies Act 2013. Minimum subscription, section 39, subsection 1. A company cannot allot securities to the public unless the amount stated in the prospectus as the minimum amount has been subscribed and the sums payable on application for the amount stated have been received by the company by check or other instrument. Application money, section 39, subsection 2. A sum of at least 5% of the nominal value of shares must have been received in cash by the company as application money or as may be specified by the Securities and Exchange Board by making regulations in this behalf. Money to be kept in a scheduled bank, section 40, subsection 3. All application money received from the public for subscription to the securities shall be kept in a separate bank account in a scheduled bank and shall be utilized only for a for adjustment against allotment of securities where the securities have been permitted to be dealt within the stock exchanges specified in the prospectus, or b for the repayment of monies received from applicants within the time specified by the Securities and Exchange Board, where the company is for any other reason unable to allot securities. Return of application money, section 39, subsection 3. If the stated minimum amount has not been subscribed and the sum payable on application is not received within a period of 30 days from the date of issue of the prospectus, the amount received from applicants shall be returned within such time and manner as may be prescribed. Return of allotment. Section 39, subsection 4. Whenever a company having a share capital makes any allotment of securities, it shall file with the registrar a return of allotment in such manners as may be prescribed. The return of allotment should state the number and the nominal amount of the shares comprised in the allotment, the name, addresses, and occupations of the allottees, and the amount, if any, paid or due or payable on each shares. Penalty. In case of any default, the company and its officer who is in default shall be liable to a penalty for each default of 1000 rupees for each day during which such default continues, or 1 lakh rupees, whichever is less. Securities to be dealt within stock exchanges. Section 40. First, application to recognize stock exchange. Every company making public offer shall, before making such offer, should make an application to one or more recognized stock exchanges and obtain permission for the securities to be dealt within such stock exchanges. Second, names of the stock exchange to be stated in prospectus. Where a prospectus states that an application to a stock exchange has been made, such prospectus shall also state the name or the names of stock exchange in which the securities shall be dealt with. Third, any condition purporting to require or bind any applicant for securities to waive compliance with any of the requirements of Section 40 shall be void. 4. Penalty. If a default is made in complying with the provisions of this section, the company shall be punishable with a fine which shall not be less than 5 lakhs rupees, but which may extend to 50 lakh rupees, and every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which shall not be less than 50,000 rupees, but which may extend to 3 lakh rupees, or with both.
Let us recapitulate what we have learnt in this module. Share is a fractional part of capital of the company. Share includes stock. Stock is the aggregate consolidated holding of the share capital of a person in the company. A company limited by shares, both public company and private company, may issue preference shares, equity shares with different rights, and sweat equity shares. Allotment of shares is acceptance by the company of the offer or application to take shares in the company. Allotment to be valid must fulfill general principles and statutory provisions. Every company making public offer shall, before making such offer, make an application to one or more recognized stock exchanges and obtain permission for the securities to be dealt with in such stock exchanges. If the stated minimum amount has not been subscribed and the sum payable on application is not received within a period of 30 days from the date of issue of the prospectus, the amount received from the applicants shall be returned within such time and manner as may be prescribed.